both in the courtroom and also online. And Mr. Compton, can you tell me what case you're here on?
The Burt matter.
Okay, very good. We're calling then Burt v. Rogers, file 23-8997 Counsel, you want to place your appearances on the record, beginning with plaintiff's counsel?
Morning, Judge West Compton on behalf of the plaintiff.
And good morning, Your Honor. Eric Stein on behalf of the defendant.
All right, good morning. And this is the defendant's motion to dismiss. I've reviewed the motion and then the response. Go ahead, Mr. Stein, with your motion, sir.
Thank you. This morning, Your Honor, we have a motion to dismiss up pursuant to MCR 2.202A1B. I know that's a mouthful. In any event, I believe that the issue has been well pled, in terms of our brief and our motion. And so I'm happy to take any questions that the court may have regarding its content.
Well, if you could maybe articulate, I know the case law doesn't require a showing of prejudice, but is there any prejudice to the late substitution or any possible prejudice you'd want to articulate on the record?
So, Your Honor, the only basis I think for prejudice in this event is that we are talking now 5 years after the date of loss. The accident occurred in the year, I think, 2020, and the case was filed a couple of days before the statute of limitations expired. And now, because of the delays caused with the death and then the proper substitution of the parties, we are now 5 years beyond that accident date, which of course makes it difficult to locate witnesses, recollections fade. And, so we would argue that just that pure, the elapse of time that goes by here is a sufficient prejudice to warrant dismissal.
Okay, thank you. Mr. Compton, plaintiff's response?
Yes, Judge. I mean, we'd rely on the response. Essentially, I think, as you indicated, the statute may not require it, but you're inquiring as to the prejudice. We don't believe that there is. We've been litigating the case. We've been dealing with this issue with getting the estate open, which we did. Honestly, I appeared before you at the last hearing, and that was taken care of. It seems as if the substitution just didn't go in, the changing of the actual party. But, I work with Mr. Stein a lot. I don't think that we're not going to be able to get it across the finish line, but I obviously think it would be extraordinarily prejudicial to us to have the case dismissed.
Well, let me ask you, I mean, when you said that this estate had been opened, we did then double check that, and we're now past 91 days from the estate being open. So even if I were to excuse the 91-day period from the notice of death, why on earth have you not substituted in the estate when it's 91 days after the estate has been opened?
Yes, Judge, that's where I mean it, for lack of a better response, it seems like the meat of it is the getting the estate open. The simple part is the substitution of the estate. And I don't know I don't have an excuse for you, Judge. I really don't, other than, I mean, I remember arguing it. Me and Mr. Stein talked afterward. In fact, we were doing that last hearing and Mr. Stein was in the waiting room, and he didn't get on the record. I mean, we had just spoke about it, and I don't understand. I am not the lead counsel on it. I did appear at the hearing. That's why I'm here. But Ms. Shanta was informed of it, and apparently the substitution we didn't get the stip over. That's my understanding. And I don't really have I wish I could say more, but I mean, that's really the issue. It looks like we did get the probate stuff done. We just didn't get it substituted over.
Okay. All right. Thank you. Any rebuttal argument, Mr. Stein?
No, I have nothing to add. Thank you.
All right. Well, this is a third-party auto negligence claim. There was an uninsured motorist and underinsured motorist claim against an insurer that is settled, and now we only have the third-party claim remaining. This case was, as of today, it's been open 782 days. It's the oldest case on my docket. The complaint was filed October 3rd of 2023, more than 2 years ago. The defendant, who was alleged to have been negligent in the motor vehicle accident, died in January of this year. Now, 11 months, almost almost 11 months ago, 10 months ago. A notice of the death was filed over 7 months ago. And as I said, it's been more than 91 days since the estate was opened. MCR 2.202 sub A1B provides that unless a motion for substitution is made within 91 days of the notice of death, the action must be dismissed as to the deceased party, unless the party seeking substitution shows that there would be no prejudice to any other party from allowing later substitution. And the Court of Appeals held in the Bradley case cited by a defendant that even if no prejudice is shown, the court may exercise its discretion to dismiss the action. Here, the defense alleges that there may be some prejudice due to the passage of time in securing or the testimony of witnesses, because it's been 5 years since the accident. You know, I'm not sure that there's a real strong showing of prejudice here. I mean, the defendant is a witness and she's passed away, but I presume her testimony has been preserved through some deposition. But there's no prejudice that would need to be required in order to dismiss it. The court rule says it must be dismissed unless there's a showing of no prejudice. And even then it's discretionary. Here, the plaintiff's response to the motion misses the mark, cites 2.313 as if this is a discovery sanction and urges the court not to impose the harsh remedy of dismissal as a discovery sanction because there's no bad faith or history of sanctions. And that entirely misses the mark. I'm just perplexed by plaintiff's counsel action in this case. As I said, it's my oldest case. It's 2 years old, 7 months since a notice of death. And even if I overlook that, even if I gave the grace of saying, once the estate was open, we're going to restart the 91 days, and we're past that with no reason whatsoever. It would have been either a STIP or not, or if it's not approved by a STIP, as is referenced in plaintiff's response, file a motion for substitution under the court rule. The plaintiff's response doesn't even cite the appropriate court rule. I think on the whole, given the length of time, the delay has been pretty dilatory here. I'm reluctant to do so, but I think it is a proper exercise of the court's discretion to grant the motion and dismiss this case. So, Mr. Stein, you can submit an order to that effect.
Yes, I will do that. Thank you.
Okay, thank you all. Have a good day.
Thank you.
For Attorney David Gryza on behalf of the defendant.
Okay. Mr. Long, I know you're stepping in for Mr. Gryza today. I do want to mention at the pretrial conference back on October 27th, I advised Mr. Gryza that the appearance that we had for him, the substitution of attorney for him for Peck, was only as to the defendant Dusty Cash. The substitution by its terms was substituting for only one defendant. And Mr. Gryza appears to have failed to remedy that. Could you please put like stars and underlines and highlights? Technically, Emily Cash is still represented by Lyle Peck, who's not present. And that's the reason why I adjourned the pretrial last time. So how am I supposed to go forward with a hearing today with an attorney, with a party who, according to my court filing records, is represented by an attorney and that attorney is not present? Mr. Long, what say you?
I do not have an answer, Your Honor. I saw the appearance. It's my understanding that we only represent Dusty Cash, but again, I'm just stepping in for Attorney Gryza. So,
okay. Well, see that's my assumption as well. But then Mr. Gryza told me, no, he intended to appear for both. So that's my problem today. So I guess, Mr. Blumberg, I hate to adjourn this again, but I mean, discovery, you're free to embark on discovery. Do you think we should go forward with a scheduling conference right now or no?
Well, I don't know, Mr. Long. I'm assuming he's in the same firm. I don't see why we can't at least conduct the pretrial, Judge. I don't understand why this hadn't been remedied, but rather than coming back a month from now, maybe we can certainly move forward with at least a scheduling order.
Okay. All right. Mr. Long, would you please pass along to Mr. Gryza? I expect him to cure this within 14 days, or he's going to have a problem with me.
Will do, Your Honor.
All right. All right. Other than that appearance issue, Mr. Blumberg, are the pleadings satisfactory?
I believe they are.
Mr. Long?
They are, yeah.
All right. Amendments would require leave of the court. Have the initial disclosures been served by all parties?
Yes, Judge, we just received the defendants. Well, and again, I don't know if it was just for Dusty Cash or whether it was for Emily, but initial disclosures have been filed by the plaintiff.
Okay. And how long do you want for discovery deadline, Mr. Blumberg?
Judge, I think 90 days at a minimum, and again, just because of the holidays, maybe 120, but I think 90 should be sufficient.
Okay, I'll do 120 just to give you that space. Witness list within 60 days, fine?
Yeah, that would be great.
All right. Do you want me to order this for mediation or just leave that up to you and the attorney to sort out?
I think the attorneys can probably try to resolve that. Thank you.
Okay. Mr. Long, is it okay if I don't order any formal ADR and just leave it to the attorneys to sort out if that's necessary?
Yes, that is acceptable.
Okay. All right. And is this is a non-jury matter, Mr. Blumberg, is that right?
Yes, Judge, it's kind of an equitable claim, so there is no jury entitlement.
Okay, estimated length of a bench trial?
I would say 2 days at the most.
Okay. And with it being a bench trial, I leave it up to the attorneys then. Do you want at the close of discovery a settlement conference with me in chambers, or would you prefer to do a final pretrial on the record?
A settlement conference is always a good thing, Judge, so I guess we would request that.
Okay, Mr. Long, any objection to that?
I agree with that settlement conference.
Okay, I just always double check with that when I'm the trier of fact. I just want to make sure council's comfortable with that, and then I leave it up to you what facts you want to share with me during that settlement conference. So let's see, 4 months out would be March. All right, so let's schedule this for a settlement conference on March 11th. At 11 a.m. All right. Anything else for purposes of scheduling, Mr. Blumberg?
No, Judge, thank you.
Mr. Long?
Nothing from me, Your Honor.
All right. Thank you very much. We'll get a settlement, or we'll get a scheduling order out to counsel. And I did write on that defense counsel must file an appearance for both defendants within 14 days. All right. Have a great day, everyone.
Thanks, Judge. Happy Thanksgiving.
So you too. All right. Good morning. Up next, we've got Starrett v. Benson, file 24-9023CZ. Counsel, you want to state your appearances beginning with the plaintiff?
Good morning, Your Honor. Kevin Cleaborn. I represent the plaintiffs.
Your Honor, Kurt Thornblade, P25858. I represent the defendant.
Okay, good morning. We've got 3 motions up today. Defense motion for relief from judgment, plaintiff's motion to enforce the judgment, and defendant's motion for bond pending appeal. I guess maybe we should first take the plaintiff's motion to enforce the judgment, because it sounded like from some of the later pleadings that came in that some of the issues raised in Mr. Cleaborn's motion may have been ameliorated. So let's take that motion first. Mr. Cleaborn, go ahead.
Can I remain seated, Your Honor?
Yes, that's fine.
Your Honor, we filed the motion as we've had possession since mid-September. And so once we had to go to the trouble of evicting the defendant, we expended costs for the sheriff's service fee. That was in the amount of $82, $200 to get the defendant's belongings removed. And then we rented a storage unit for a month, and we've expended $40 on that. I was hoping the defendant even might be here so I can pass off the storage unit key to the unit so he can remove his stuff. The only other issues that I can see is that he's moved his jet boat and a couple of jet skis a little, and there were 3 vehicles there. They appear to be still on the plaintiff's property, and so we were asking for in order to just get those off. He's got the 2 vacant lots next door. It would not be too difficult to move those items to his own property. So anyway, we don't know where the defendant is now living, but obviously he's been living elsewhere for a couple months now. So we're hoping to get repaid for our $322 that we've expended and get all of his property off our property.
Okay, Mr. Thornblad, your response to that motion?
Yes, Your Honor. Our response was to ask to have this held in abeyance simply because if Mr. Cleavorn would share with me what it is that he wants, I probably could stipulate to it subject only to not waiving our appeal rights on it. So
Well, I mean, he told you what
if I were given the information, I might agree to it. Good chance.
All right, well, Mr. Thornblad was given the information by way of the motion, which stated very specifically what the plaintiff wants. There's been no reason not to do that. Plaintiff's motion to enforce the judgment is granted. I would sign an order, Mr. Cleavorn, ordering the defendant to pay $322 in costs and order the defendant to remove any property still remaining on the premises and out of within 21 days. And you can submit.
Your Honor, if that's the extent of the relief Mr. Cleavorn wants, I could stipulate to that subject only to, I don't want to waive the appeal rights on it.
Oh, sure. Okay. All right. So I'll enter that as an order, not as a stipulated order then, so that there's, appeal remedies is fine.
That'd be fine.
Where should I send the key?
Yeah. So Mr. Thornblad, Mr. Cleavorn has some personal property that they have removed from the premises and placed in a storage unit. Where should he send the key? Should he send it to your? Okay, send it to Mr. Thorn.
Oh, 7301 Schaefer, Dearborn, Michigan, 48126-4915.
Okay, very good. All right, you can submit an order to that effect, Mr. Cleavorn. And now we have defendant's motion for relief from judgment and motion for bond pending appeal. Maybe we could hear argument on both of those motions at the same time. Go ahead, Mr. Thornblad.
Thank you, Your Honor. This motion rests on 2162 C1, C, and F. I do acknowledge that in the original motion, the title page had subsection B in it, but we are not relying on it. We're relying on C and F. C would be a fraud or misstatement on the court. The affidavit of Dr. Starrett and his sister both indicate they were not aware of the deed for a long period of time. That's the affidavit. The court put the onus on us to show that the 15 years had passed. However, there was a mortgage that was referenced by a defendant in his deposition. The mortgage was entered within months of the deed being recorded. That it puts the plaintiff's awareness of when it was recorded past the way earlier than the 15-year period at the time of the filing of the case. And also it establishes the estoppel. I would just say in this case, this is a family dispute. That's the most vicious backbiting form of a litigation. There are no good guys. There are no bad guys. Everything has to be corroborated. The doctor's statement is not corroborated.
All right, thank you. And as to your motion for bond pending appeal, anything you want to say about that?
Yeah, brother counsel pointed out I had a reference to a statute which is in a positive. I filed a response and I withdraw any claim of support on that. I do state that I've been a lawyer 50 years. I've filed a lot of appeals. I have never had a judge grant me a stay pending appeal. The judge has to, first of all, admit that there's a probability that he'll be reversed. I've never had a judge do that, but the Court of Appeals asks us to go to the trial court first in their wisdom, and I'm doing that. So I just ask Your Honor, if you find it in your heart after reviewing the file that it should be stayed, maybe we could just arrange for my client to be able to stay in the property and pay some reasonable rent, like $750 a month.
Mr. Thornblatt, I have to tell you, that is my favorite argument I have heard in the last 5 years. All right, Mr. Cleaborn, your response.
I am chuckling as well, Your Honor. Your Honor, I feel like I'm re-arguing the summary disposition motion again, but the court granted our motion on the deed delivery issue. It dismissed his claim for adverse possession because he admitted it was communal and that he had not been there. And so that's the reason the court dismissed the defendant's counterclaim for adverse possession. But again, from his deposition, the court properly granted our delivery of deed issue because when I asked him where the deed was, quote, this is page 24 of his deposition, "I have no idea where the deed was. It might have been in my grandmother's possession. It might have been in my mother's possession. I didn't have it. I didn't even know it existed." Question number 2 then. "And you have no idea where your mom kept it or where the deed was?" Answer, "I have no inkling." And so, I mean, that's the reason why the court properly granted our relief on the delivery of the deed issue. And so, again, I'm just a little puzzled at this whole motion, quite frankly. I guess with regard to the bond issue, the status quo is he's been ordered out and he's been out since mid-September. And so the place has already been secured. It's been winterized, pipes blown out, that kind of thing. Obviously, he's been living somewhere else for 2 months.
I do have one question for you about the bond pending appeal, and I would not be inclined to allow defendant to resume possession of the premises. So I'm not going to stay the possession or the legal effect of the order. However, he has pursued his appellate remedies, and your client, as it sits today, could simply sell the premises. And then if the defendant prevailed on appeal, he'd be left essentially without a remedy. So should I at least grant the motion in part to allow him to file a lis pendens or something?
I guess so. It's a family compound. And so I think that order would be academic, if you will. I mean, there's no... The Sterretts have cabins next to each other. The purpose for all of those parcels up on Carp Lake is to have a place for family gatherings.
So you're stating that there's no present intention of your parties to alienate the premises?
No, none whatsoever.
All right, thank you. Mr. Thornblatt, any rebuttal argument, sir?
No, thank you, Your Honor. That would be a sensible resolution of this matter. If we could just file a lis pendens, I think that substantial justice would be done.
All right, thank you. Well, as to the defendant's motion for relief from judgment, I'm going to deny that motion. It's based upon some information from a mortgage that shows that in the spring of 2003, the plaintiffs had secured the defendant's signature on a mortgage, showing that they had some knowledge of his asserted interest at that time. However, the basis for the summary disposition was the failure to deliver the deed prior to the grantor's death. The 2003 mortgage does nothing to change the fact that there was no delivery or recording of the 2000 deed until after the grantor's 2002 death, and that the plaintiff didn't know about the deed until sometime after the grantor's death. So there's no showing of fraud or other reason to grant relief from judgment. That motion will be denied. The motion for bond pending appeal will be denied in part and granted in part. And the relief that I would grant is I would not stay the order pending appeal or grant defendant possession of the premises, but I would allow defendant to file a lis pendens with the clerk's office indicating the ongoing appellate litigation. And Mr. Cleaborn, I guess since you have prevailed on the motion for relief from judgment and substantially prevailed on the motion for bond, could you submit an order of those as well?
Sure.
Okay. And you can combine them all.
Yeah, I'm willing to do it. I don't see why we should lose time going through the 7-day motion. I'd be willing to stipulate if Mr. Cleaborn wants to send it to me.
Okay, great. Okay, great. So you can just prepare a stipulation as to form and combine all three motions in one order is fine.
Okay.
All right. Anything
you,
else,
John.
Mr. Thornblatt?
No, Your Honor, thank you. I would urge 53rd Circuit to adopt my file. The clerks like it. They adopted it in 25th and 19th just recently, and I was down there talking to the clerks, and the ladies in the clerk's office were very happy to have my file, so I asked you to consider that.
Yeah, you know, we're actually in progress with that. We need our probate courts to switch a technical issue on the case management system that's scheduled for January. And we are on the schedule to go to my file sometime next spring or summer.
Thank you, Your
So
Honor.
yes, indeed. We are looking forward to it.